Good evening, everyone, and welcome to the Ford Presidential Library. And most of all, welcome to our very first speaker program of the fall 2016. We're delighted to have you here on a beautiful evening, so we think you've made a good choice tonight. My name is Elaine Didier, and as many of you know, I'm privileged to serve as the director here both at the library and at the museum in Grand Rapids. Tonight's program is brought to you, as usual, by our parent organization, the National Archives and Records Administration, with essential support in addition from the Ford Presidential Foundation. We're very grateful to those of you who are members of Friends of Ford because that's how programs like this are provided this evening. Tonight's program is being taped by the University of Michigan's Michigan Media, and when we get to the question and answer program afterward, I hope you will bring your questions to the microphone at the back of the center aisle so that everyone, not just here tonight, but those who watch the program later on cable television will be able to hear your programs. So, on to tonight's festivities. This program has been planned in commemoration of Constitution Day, which is this Saturday, September 17th. And this particular program has been nearly 2 years in the planning. We first contacted Linda Greenhouse to invite her to speak here last September, but she laughed because she was already long booked. So we booked far ahead, and we are thrilled that she was able to put us on her calendar for this evening. She is one very busy lady, especially at this time of year. We're going to hear tonight from Linda Greenhouse, who is one of the most highly respected experts on the Supreme Court. And tonight she will be discussing the legacy of Justice John Paul Stevens, who, as many of you know, was appointed to the court in 1975 by President Ford. Linda Greenhouse spent nearly 4 decades reporting on the Supreme Court for the New York Times. During that period, she won a Pulitzer Prize in 1998, quote, for her consistently illuminating coverage of the Supreme Court. And she earned a reputation as an authoritative and insightful chronicler of the Supreme Court and its justices. She has covered numerous milestone decisions with an unprecedented insight into the workings of the court. And she's had a uniquely influential platform for detailing the impact of the court's decisions, not only at the Times, but also as a regular on PBS Washington Week and many other programs. Today, she continues to write a biweekly op-ed program on law for the Times while serving as a faculty member in the law school at Yale University. She has received dozens of major journalism awards and is well known for her writing in the humanities and jurisprudence. She's a graduate of Radcliffe College and learned a Master of Studies in Law from Yale's Law School, and in addition has been awarded 11 honorary degrees. That's a pretty significant number. In addition to writing for the Times, she has documented the court in 3 books and has a brand new book just out, The Burger Court and the Rise of the Judicial Right, which she co-authored with Michael Gratz. This is a comprehensive evaluation of the Warren Burger Supreme Court, describing how the court moved toward the right of the political spectrum and established the conservative legal foundation for the years that followed. And we do have books for sale, and she will be signing books afterwards. So even though that's not her topic this evening, she'll be glad to talk to you about this new book. So with all of that as background, you can see why we are thrilled and honored to have Linda Greenhouse with us this evening.
Well, I really am delighted to be here in such a big crowd to come out for Constitution Day. So just to give a little background on Constitution Day to explain, I'm not always so busy a year in advance, but back a few years ago, Senator Robert Byrd got a bill passed, or a rider on the federal education bill, that said that every institution of education that receives federal money, and that's basically all of them, has to observe the anniversary of the Constitution on September 17th. They have to do something. So that something has evolved into get somebody to come and talk about the Constitution, and it's only one day. And so when this first came in, I was saying earlier, the colleges sort of hadn't gotten the hang of it, and they would call around Labor Day to say, Now they really book. So last year, instead of coming here, I had 2 back-to-back, sort of in the same neck of the woods, Smith College and the University of Massachusetts at Amherst. So I could not squeeze in Ann Arbor at that time, but I'm really happy to be here today. So to my prepared remarks, I wanted to explain at the outset why I've chosen this occasion, this Constitution Day, here in this particular fascinating library, of which I got a brief tour, to talk about, not the president, but a retired Supreme Court justice, not perhaps the most obvious choice of subjects. But here's the reason why when I received this invitation a year ago, this is the subject that jumped into my mind as the best and the most logical choice. In 2005, Fordham University Law School held a symposium to mark the 30th anniversary of Justice John Paul Stevens' appointment to the Supreme Court. President Ford, who was then 92 years old, did not attend, but he sent a letter to the law school's dean. And this is what he said, quote, "I am prepared to allow history's judgment of my term in office to rest, if necessary, exclusively on my nomination 30 years ago of Justice John Paul Stevens to the U.S. Supreme Court." That's an amazing statement. Think about that. Why would a former president of the United States offer such an endorsement? So that's the subject. In fact, that's the reason for my talk this evening. To begin with the obvious, Gerald Ford, a graduate of Yale Law School, knew the court and he knew the Constitution. Although in 2005, Justice Stevens had 5 more years to go in his nearly record-setting Supreme Court tenure, the 30 years he had already served by then offered President Ford plenty of evidence from which to draw his conclusion about his only Supreme Court nominee. By then, Justice Stevens had carved a role for himself as the thinking person's justice. He himself was a former Supreme Court law clerk, having graduated in 1947 from Northwestern University Law School, which he attended on the GI Bill after a distinguished record in World War II, with the highest average in the school's history. Not only was he very smart, he also knew a lot about law, more than a lot of justices today, I have to say. Having practiced in the federal courts for 22 years before he himself became a federal court of appeals judge on the 7th Circuit in Chicago. He earned a stellar reputation within the Chicago bar as a lawyer's lawyer, keeping those habits of mind, which included meticulous attention to the facts and context of every case. He became, not surprisingly, a lawyer's justice. When Justice William O. Douglas retired 2 months into the 1975 term, debilitated by a stroke, President Ford wanted a Supreme Court nominee with unimpeachable credentials who could win quick Senate confirmation and not present any kind of political problem on the eve of the 1976 presidential election campaign. So he tasked his Attorney General, Edward Levy, with finding such a person. Levy, a former president of the University of Chicago, John Paul Stevens' undergraduate alma mater, knew Judge Stevens and recommended him highly. 2 weeks later, Judge Stevens was the nominee. 19 days after that, he was confirmed by unanimous vote. Those were the old days. Think about that. A simpler age in more ways than one. And here's one of the other ways. John Paul Stevens was the first person nominated to the Supreme Court since the court in January 1973, in other words, almost 3 years earlier, had decided Roe against Wade, recognizing a woman's constitutional right to abortion. Justice Douglas had been a member of the majority in Roe, so it might have been natural to wonder whether a Republican president's first post-Roe nomination would see the matter, first post-Roe nominee would see the matter any differently. And some years ago, I wondered about this myself. So I got the transcript of the Senate confirmation hearing for John Paul Stevens to see what he was asked about abortion. I couldn't find a single question. Thinking I must have missed something, I read through the entire transcript again. Still nothing, not one question. So this tells us that nearly 3 years after Roe, abortion had not yet become the politically polarizing issue that we see it as today. I actually had occasion to ask Justice Stevens a few years ago whether he was as surprised by the senator's lack of interest in his views on abortion as I was. Not at all, he said, because the Supreme Court had settled the issue and there was really nothing to be said about it. A simpler age, as I said. For perhaps the first half of his Supreme Court tenure, court watchers didn't quite know what to make of John Paul Stevens. The court was not as polarized then as it is now, but still, there were identifiable ideologies on the bench, and Justice Stevens seemed to share none of them. He was known more for his ubiquitous bow ties than for his opinions. He was unpredictable, people said, even, quote, quirky. That was commonly applied to him. And what did that mean? It meant that nobody could take his vote for granted, that he thought for himself. While he was respectful of precedent, he never hesitated to call the court out when he thought that the justices or the precedents on which they were relying were headed in the wrong direction. Take one example for any lawyers in the room, the equal protection doctrine. By the time he arrived at the court, equal protection had become an exquisitely complex set of rules intended to figure out how the Constitution's guarantee applied to a given set of facts. Some cases involving race were evaluated under strict scrutiny. Economic regulations that affected people differently would be upheld as long as the judge deemed them to be rational. In 1976, in an early sex discrimination case, the very junior Justice John Paul Stevens announced that he was getting off that bus. Quote, "There is only one equal protection clause," he declared. "It requires every state to govern impartially," period, unquote. He was very critical of Buckley against Vallejo, the court's early venture into the realm of campaign finance regulation that treated independent campaign expenditures as a form of speech entitled to full First Amendment protection, which meant, as we were to learn decades later in Citizens United, and from which Justice Stevens vigorously dissented, that political spending that claimed to be uncoordinated with a candidate escaped regulation. Money is not speech, Justice Stevens has said repeatedly. It enables speech, of course, but it's not speech. In his amazingly fruitful post-Supreme Court career, one of the 2 books he has written is called 6 Amendments, consisting of his proposals for fixing the Constitution or saving it from the Supreme Court's misinterpretations. One amendment would make clear that the First Amendment permits reasonable limits, as he put it, on campaign spending. That would be very interesting. Another of his proposals would amend the 8th Amendment by including the death penalty among the amendment's prohibitions on cruel and unusual punishments. The death penalty is a classic John Paul Stevens story. 3 years before he joined the court, the justices in the Furman decision had invalidated all existing death penalty statutes, instructing the states to eliminate randomness by constraining the jury's discretion to decide which individuals merited the ultimate punishment. New state laws aimed at overcoming the court's objections were making their way back to the Supreme Court. And in 1976, Justice Stevens voted with the majority to uphold most of the new laws. That was the start for him of a long journey. He was acutely attentive to the fact that the randomness was not disappearing from the system, as a newly empowered conservative majority on the court put increasing limits on the right of death row inmates to appeal and on the ability of federal judges to set aside unjust state sentences. Finally, in 2008, Justice Stevens renounced the death penalty as a failed experiment. That case, called Bays against Reese, concerned the constitutionality of lethal injection, but Justice Stevens' separate opinion went further. He said that while he had voted years earlier to reinstate the death penalty on the promise that it could be carried out fairly and without discrimination, he had become persuaded that decisions by state legislatures, by Congress, and here I'm going to quote a paragraph, by this court, to retain the death penalty as part of our law are the product of habit and inattention, rather than an acceptable deliberative process that weighs the costs and risks of administering the death penalty, of administering that penalty against its identifiable benefits, and rests in part on a faulty assumption about the retributive force of the death penalty. And he continued, the time for a dispassionate, impartial comparison of the enormous costs that death penalty litigation imposes on society with the benefits that it produces has surely arrived. The weight was all on the cost side, he said. There was no measurable benefit to maintaining a system of capital punishment. But then he did something that no other justice that I've observed over the years would have thought to do. He still believed in precedent, Justice Stevens wrote. He would vote with the majority to uphold the challenged lethal injection protocol. He would not, as Justices Brennan and Marshall had done years earlier, simply dissent, usually without opinion, from any case in which the court upheld the application of the death penalty. Justice Stevens didn't quite say this, but I believe what he was really saying was that he didn't want to take himself out of the conversation, that he thought he was right, that the evidence was on his side, but he would stay in the game and keep calling his colleagues' attention to the failings of the court's death penalty jurisprudence. Since his retirement, this role has been assumed by Justice Stephen Breyer, who called for the abolition of the death penalty in an impassioned dissent in a subsequent lethal injection case last year. So that work goes on. The death penalty was only one area in which Justice Stevens permitted his thinking to evolve. He was quite skeptical of affirmative action during his early years on the court, but his thinking on this subject was always nuanced, never doctrinaire. The position he came to hold was that the government may take race into account in order to build a better future for all its citizens. This audience, I suspect, is well aware of the struggle in Michigan over admissions policies at the state's universities. In the Grutter decision in 2003, which is what upheld the University of Michigan Law School's admissions policy, President Ford played a backstage role, as some of you may know. Are people aware of this? Yes? No? As I understand the story, anyway, it was President Ford's idea, conveyed to the lawyers defending the admissions policy, that is to say the university's lawyers, to bring in the military perspective. The president knew that the military was committed to affirmative action at the military academies, West Point, Annapolis, and so on, in order to produce a diverse officer corps to lead a diverse military. A Washington, D.C. lawyer named Carter Phillips took up that suggestion and filed an amicus brief on behalf of a group of retired superintendents of the military academies. And Justice Sandra OConnor invoked this brief in her majority opinion that upheld the law school's policy. With Justice Harry Blackmun's retirement in 1994, Justice Stevens became the Supreme Court's senior associate justice. And the senior justice, in terms of actual seniority, was Chief Justice Rehnquist, but that was a formality. The Chief Justice is always deemed the number one in seniority. And actually, Rehnquist was the number one in seniority, but he didn't have to be deemed the number one. So the one privilege of being the senior associate justice is to assign the opinion in those cases in which the Chief Justice is in dissent. If the Chief is in the majority, then the Chief makes the assignment, but the senior associate justice in the majority gets that privilege if the Chief is in dissent. This may not seem like a very substantial prerogative, but in the life of the Supreme Court, it's actually quite significant. Assigning the opinion, especially in a closely fought case, is a delicate task. The opinion writer may have to walk a fine line in order to hold a fractious majority together and not have a colleague slip away and join the other side and have the case come out in the opposite way. Justice Stevens enjoyed this position for more than 15 years, and he used it to the fullest. Since he was well to the left of the two Chief Justices under whom he held this position, William Rehnquist and then John Roberts, He got to use the assigning power when it really mattered, when the more liberal justices have been able to cobble together a narrow majority, almost always with the assistance of Justice Anthony Kennedy. Justice Stevens is a bridge player, and he knows how to play cards. He rather often assigned major cases, such as Boumediene, the court's major Guantanamo-related case that recognized the right of the Guantanamo detainees to file for habeas corpus, to Justice Kennedy, in order to hold his vote by making him fully invested in the outcome. Excuse me. Justice Kennedy himself is now the senior associate justice, a position he inherited when Justice Scalia died in February. And given his pivotal role on the court, this is a very interesting position for him to hold. That's just an aside. Justice Stevens assigned the University of Michigan Law School case, Grutter, to Justice O'Connor, an unexpected member of the majority and someone who was willing to go a certain distance, but no further. It was a very strategic appointment and very typical of Justice Stevens, who could have chosen to write that himself, but he had to hold Justice O'Connor to that opinion. I have to mention one other aspect of Justice Stevens' jurisprudence, his strong belief in the separation of church and state. His view on the Establishment Clause was instinctive and instructive. He wasn't shy about expressing his view that religion, as religion, holds no favored place in the constitutional framework. He was, for example, the only justice willing to strike down anti-abortion laws, not only for violating the right to abortion, but for violating the Establishment Clause by writing into law a particular religiously based view on when life begins. As the current Supreme Court, under Chief Justice Roberts, has all but effaced the Establishment Clause and the individual freedom that it protects, Justice Stevens' voice is missing from the constitutional discourse, and in my opinion, we are poorer for that. As to explain his liberal trajectory during his decades on the court, Justice Stevens has usually said that he didn't change, the court changed around him. To some degree, that's true. Even with the death penalty, which Justice Stevens might have been content to leave untouched had he not felt that the court's decisions limiting appeals had introduced too great a risk of discrimination and error. Still, it's impossible not to notice that by the time he announced his retirement in the spring of 2010, soon after delivering his impassioned dissent in Citizens United, Justice Stevens was the most liberal member of the Supreme Court. How did this happen to a Midwestern Republican antitrust lawyer? At the Fordham Symposium that I mentioned at the beginning of this talk, Justice Stevens offered what might be taken as an explanation: learning on the job. Quote, "I know that I, like most of my colleagues, have continued to participate in a learning process while serving on the bench," he said. Quote, "Learning on the job is essential to the process of judging. At the very least, I know that learning on the bench has been one of the most important and rewarding aspects of my own experience over the last 35 years, he said. One of Justice Stevens' retirement projects was a memoir, 5 Chiefs, published in 2011. In this little book, he uses his encounter with 5 successive Chief Justices to tell the story of his own career. There's a great deal of wisdom and substance in this book, delivered with such a subtle touch that I think many people who've read it have dismissed it as an enjoyable but rather light read. In fact, it's full of interesting and provocative observations. On the subject of learning while on the bench, I will offer you just one incident from that book. It concerns a 1991 decision in a case called Harmelin against Michigan. I seem to have a Michigan theme here, I don't know. In which the majority upheld a life sentence for a first-time drug offender, applying a rigidly doctrinaire view of sentencing and rejecting the concept that proportionality is part of the Eighth Amendment. In the book, Justice Stevens spoke of his dismay at this outcome, and he took gentle aim at Justices O'Connor, Kennedy, and Souter, who had all voted in the majority. He noted that all 3 were relatively new to the court, replacing Justices Stewart, Powell, and Brennan, respectively. Those retired justices would have joined the dissent, not the majority, Justice Stevens said. And then he added, quote, "Moreover, just as the meaning of the Eighth Amendment itself responds to evolving standards of decency in a maturing society," and that's a line from a famous Eighth Amendment decision of an earlier age, "so also may the views of individual justices become more civilized after 20 years on the court," unquote. 15 years have now passed since the Harmelin decision. Has the court become more civilized in the interim? If Justice Stevens were here, we could ask him, and he would tell us exactly what he thinks. I'll close by quoting my late colleague, Anthony Lewis, who, after Justice Stevens' retirement, wrote in appreciation that Justice Stevens had that rarity, a genuinely independent mind. No wonder President Ford was so proud of having appointed him, and we should all be grateful. I know that I am. And it's an honor to have the chance to share these thoughts with you on this special day in this very special place. Thank you. So as you heard earlier, there is a standing mic in the back of the room. And if people would like to ask questions, you are strongly encouraged to use the mic.
In your appearance at Politics and Prose recently, you called Richard Nixon a very lucky man to be able to appoint 4 justices. And indeed, your book clearly indicates the importance of those 4. So I would enjoy a little speculation here. How lucky do you think the next president will be? And maybe more, I'm not asking you to predict deaths of justices, but do you think it's possible that certain justices may decide to retire if Hillary Clinton becomes president? Other justices might decide to retire if Donald Trump becomes president.
Okay, I've learned over a long time of answering questions like that not to presume that I know anything more than I know. And I don't know of any current justice who's looking forward to retirement. So we know there's a vacancy, obviously. Whether in the next 3 years there'll be another vacancy, I guess the odds are pretty fair that there will be, but is that a slam dunk certainty? Absolutely not. And, you know, would I have predicted Justice Scalia's death? No, no. So, you know, I mean, that's a reason why there's kind of a slightly under the radar, but maybe people are aware of it, you know, conversation about term limits, which would, you know, regularize this crazy process. And so it would be, you know, the randomness of Richard Nixon having 4 appointments in 3 years and Jimmy Carter having none. You know, would not occur. But I wish I knew how to answer your question, but I don't know the answer.
And then a quick related question. An op-ed in last month's New York Times talked about how evangelicals are going to be voting for Trump because of what he said about appointing Supreme Court justices. How much do you think voters take possible Supreme Court appointments into account when they vote?
Well, usually not at all. I mean, the court is usually a non-issue, you know, sadly, in a campaign. I mean, in the last election in 2012, you know, between President Obama and Mitt Romney, they didn't get a single Supreme Court-related question in any of the presidential debates. I was really surprised by that. You know, I gather in the, you know, in Trump land, the court, you know, is an issue on the table for those people. I think probably less so for sort of mainstream voters, but it should be an issue, certainly should. And, you know, I mean, you referenced my book, that was very nice of you, thank you, The Burger Court and the Rise of the Judicial Right, you know, which really does document what happens when a president is determined to change the direction of the Supreme Court and has the opportunity to do it and takes that opportunity. So, yeah. Yes?
I seem to remember that Judge Stevens had very strong words after the Gore versus Bush decision. I'm not sure it was called Gore versus Bush.
Bush against Gore, yeah.
Yeah. Would you comment or make some comments about what he said and what you think about it?
Yeah, well, there were 4 dissents in Bush against Gore, and his was one of them. And it was a very strong dissent, and he said, I wish I could quote it, he said something to the effect of, among the losers tonight is the Supreme Court itself and its legitimacy before the public because of what he construed as a raw political decision. So he felt very strongly about it. But I mean, so did Justice Souter, Justice Breyer, and Justice Ginsburg. They were the other 3 dissenters, and they each wrote strong dissenting opinions. Yeah.
Yes, I have a question of whether or not you believe that decades ago justices of the United States Supreme Court were not viewed primarily as partisan members of the court, but as members of the court appointed by a particular chief executive. And if this is true, it's my take that that's not the case today, whether you can conceive of us ever getting back to a situation where that would be true.
Yeah, so you can say it's never been true before when you look at, say, the New Deal court, that provoked the court packing crisis and so on. The old guys who were striking down all the New Deal legislation, it certainly was a highly partisan, inflected, polarized situation. What's unusual today, and I'm not sure that this, as a formal matter, was the case with the New Deal court. What's really unusual today, following the retirements of Justice Stevens and Justice Souter, and before them Justice OConnor, is that all the liberals on the court were appointed by Democratic presidents, and all the conservatives were appointed by Republican presidents. That's different, because after all, if you look at, say, the Warren Court, Dwight Eisenhower appointed Earl Warren, Republican governor of California, who had run on the national ticket, had run for vice president on the Tom Dewey ticket in 1948. I mean, he was a Republican. He became this very liberal Chief Justice, and of course, Justice Stevens, as you just heard, so that people could look at the court and they could see that the court was very closely balanced, and you could say quite polarized, but you couldn't identify it as, dancing with the president that brought them, and now that is the case, and it puts the court in a dangerous position. I think it's very unfortunate. Will we ever get back to a time when one's instinct wasn't, if you heard about a judicial decision, it wasn't immediately to look up which president appointed that justice or judge? I don't know. I wish I could be confident that we would get over that. But I read a really interesting story in USA Today this morning by their Supreme Court reporter, Richard Wolff, who looked at all the voting rights litigation that's going on in the country. All this voter ID stuff and early voting and all this, around the country, and a dozen or more states, there's litigation like this. And the lower court federal judges who are striking down these voting restrictions are all appointed by Democratic presidents. The judges who are upholding these restrictions are all appointed by Republican presidents. It's a really bad situation, very unfortunate. Yes?
Welcome to Michigan in this beautiful fall weather. This is, of course, the reason people live in Michigan, days like this, so we're glad to have you here. My question goes back to Roe versus Wade that you mentioned earlier, and the fact that Roe constantly has a target on its back. And with how quickly society had this social revolution of really same-sex marriage with Obergefell versus Hodges, do you think that court case is going to have a target on its back? Or as society, have we really agreed to this social change, which is so momentous for so many lives?
Well, that's a really deep question. So I have a few things to say about that. Let me say them sort of in some kind of coherent order. So the story with Roe is a very fascinating one. Let me backtrack to that for a minute as a kind of a predicate. So, a lot of people assume Roe against Wade must have been a 5-4 decision, right? It was 7-2. 3 of Nixon's 4 appointees were in the majority, all but Rehnquist. Those justices in the majority in Roe against Wade did not think they were doing anything terrifically radical. Why? Because they were reflecting the strong view of their peers in the professions and the elites of the legal profession and the medical profession, that as a matter of public health and the autonomy, not of women. Roe is not a feminist decision. It's kind of paternalistic, actually. It's a decision about doctors and the right of doctors to practice medicine in what the doctors deem to be the interests of their female patients. That's what they thought they were doing. And in fact, a Gallup poll on the eve of Roe showed that a quite impressive majority of all demographic segments, including Catholics and including Republicans by about 2/3, answered yes to the question, do you think abortion should be between a woman and her doctor without the state? So what happened? How did it become so polar? Some people say, well, the Supreme Court went too far and they created this backlash. No, that's actually not historically accurate. What happened was some very smart Republican strategists, Patrick Buchanan is a name you might recognize, and a few others around Richard Nixon, decided that abortion would be a really handy issue to peel away the urban, ethnic, mostly Catholic, Democratic voters in the North, just the way the Nixon Southern strategy has succeeded in peeling away the white Southerners using race as the weapon from their traditional home in the Democratic Party. So abortion was identified very cynically as a tool for party realignment, and it took years for that to be accomplished. Not only the Justice Stevens getting no questions, which I still find amazing every time I mention that fact, but the first Republican Party platform after Roe in 1976 was still a big tent on abortion because most Republicans favored the right to abortion. It wasn't until 1980 that the Republican platform turned on abortion. So, it's a complicated story. So, brings us to your question about Obergefell, same-sex marriage, gay rights, and so on. And obviously, there's a lot of turmoil in some communities, the bakers who don't want to bake and the florists who don't want to arrange the flowers and all that kind of stuff. And that's being litigated. But that's on the fringe. Those are marginal. That'll get sorted out. I think, there's a great societal acceptance, I believe. The polling indicates in sort of mainstream America for the rights of gay men and lesbians to get married to those whom they choose to marry and to have equal rights. And, the court struggled with this. Bowers against Hardwick in 1986, in which Justice White, rejecting the gay rights claim, famously said the claim was facetious. And it took until 2003, Lawrence against Texas, and the Kennedy opinion that explicitly overturned Bowers. So, the court didn't exactly, jump into this, but by the time the court acted, back at the time of Bowers against Hardwick, Justice Powell, who was the swing vote, 5-4, and he had a lot of trouble making up his mind, and he famously said to one of his law clerks in trying to figure out, he couldn't quite understand the claim. He said, I don't believe I've ever met a homosexual, he said to his gay law clerk. But by the time the court decided Lawrence against Texas, gay people at the court were comfortably out. Chief Justice Rehnquist, who was a dissenter in Lawrence and politically conservative, but not prejudiced in his own interactions, his top assistant was an out lesbian woman who would bring her partner and their interracial adopted children to parties at the court, and nobody had any issue with this. And so the justices themselves and the building, the society, the little society in which they live, had become, was transformed in those 16 or 17 years between Bowers and Lawrence. And I think that reflects, the experience of many of us in this room and people that we know. So I don't think that Obergefell will become that kind of target, and there's not the slightest chance that it will be overturned or cut back. But thanks for the question.
Justice Ginsburg was recently quoted in the press as saying, in her opinion, there was really no way to force the Senate to confirm a justice. So in your opinion, is that true? Is that accurate? And what is the end result if the Senate refuses, it's so polarized, refuses to confirm Justice Scalia's replacement and maybe others?
Right. No, of course, Justice Ginsburg is right. I mean, there's no way to force the Senate to give its advice and consent. The only remedy is in politics, is, for people to care enough about it that they put the voters' constituents put political heat on senators or vote them out of office or, whatever. But, we'll see in this election whether the incumbent Republican leadership pays any kind of political price for what they've done to Chief Judge Garland. I don't know, but that's the only remedy is politics. Sir.
As I understand it, the Constitution provides that Congress shall determine the number of justices on the federal courts, including the Supreme Court.
That's true.
And when Abraham Lincoln was elected, Congress exercised that power and reduced the number of justices on the court. In the polarized political environment that we have now, it's my understanding that there hasn't been any discussion of this on the Republican side. Can you explain that?
You mean just kind of freezing the court at 8, for instance? Or, well, I mean, it's true, the Constitution says nothing about the number of justices. I think the takeaway from the court packing crisis of the 1930s is that Congress is not going to mess with the number 9 again. Not that they couldn't, but I haven't heard anybody say that that's the way to go. I mean, I think the Republicans would like to think they'll get the White House back someday, and they'd like to fill the court themselves.
In the case of Lincoln, they reduced the number.
Mm-hmm.
And it seems to me that that would be a possibility with a Republican Congress and Hillary as president.
Oh, I see what you're saying. It's the opposite of the court packing, but it's the politically driven playing around with the number of justices. I don't think is politically viable, and I think that's why we haven't heard about it. For years on the D.C. Circuit, which I think has an authorized strength of 11, the Republicans in the Senate refused to let a series of presidents fill 2 seats, saying, all we need is 9. If 9 was the number, maybe it was 8. One of the people that they blocked from getting a hearing was Elena Kagan. She had the last laugh, but now they're filled. But so I mean, it's an interesting question, but I haven't heard of anybody suggest that was going to be a strategy.
This is very open-ended, but in a country that's still predominantly Protestant, you have the justices being predominantly Catholic and Jewish. Just wonder what your thoughts are on the matter.
Yeah. So we've got 5 Catholics and 3 Jews on the court right now, and Justice Stevens was the last Protestant. Not forever, I wouldn't think, but I think recent Republican presidents have viewed putting Catholic justices on the court as kind of a proxy for putting people who would vote to overturn Roe against Wade. You can't deliberately ask a potential nominee about that, so you look for a conservative Catholic who might be so inclined. Not Sonia Sotomayor, she's also Catholic, but that's different. You know, I don't think there was any kind of effort to find 3 Jewish justices. I think it just happened that way. So, you know, it's just interesting. I mean, throughout history, those characteristics of people who are nominated to go on the court, or who are the characteristics that are deemed important for a president to take account of in filling a vacancy on the court, have changed over time. For instance, there always was a Southern seat, because the South was viewed as, you know, having a kind of a different voice, a different set of interests. There should be a Southerner on the court. And that kind of fell away. I mean, it's true Clarence Thomas is from Pinpoint, Georgia, but he was really a Washington bureaucrat at the time that he was appointed. So that's fallen away. And now, of course, it would be pretty unthinkable to have an all-white court. You know, President Obama felt it was valuable to have, you know, be the first president to name a Latina to the court. You know, gender, obviously, I wouldn't expect ever to see an all-male court again. So, you know, these things change, and I think on the religion side, you know, we probably don't think that religious differences at that elite level are as significant as they once were. Maybe we should, maybe we shouldn't, but I think that, you know, kind of reflects that. Sure.
Yes. What is your opinion of Trump pre-announcing his list of so-called, you know, potential nominees? And what is your opinion of some of these individuals, please?
Well, I mean, I think, you know, I'm willing to assume that Donald Trump had not heard of any of these people. But they, you know, they're substantial members of the judiciary the names were served up by, you know, conservative interest groups, the Federalist Society, the Heritage Foundation, and so on. And, you know, they're all perfectly valid contenders to be on the Supreme Court. I wouldn't, you know, knock them. It was kind of an interesting strategy to put those names out because, you know, most people never heard of any of them. But, you know, they're logical choices for a conservative president.
So my question has to do with Ginsburg's comments about Trump and your thoughts about the crossing of a line politically. And at the same time, there was talk about Clarence Thomas and what he does. Also, if you can talk about sort of crossing that political line on the part of Supreme Court justices.
So how is Thomas, tell me the equivalency that you're drawing there.
When Ginsburg was, when she made her comments, there was a lot of reporting about what Clarence Thomas does by going into fundraisers with his wife, who's very involved with conservative causes. Not to the same extent, certainly, that Ginsburg did, but it brought up that he seems to be politically active behind the scenes.
Yeah, or I'd say the one who more than Clarence Thomas shows up at conservative events is Justice Alito, rather famously does. You know, they're probably all well advised to stay away from politics. What can I say? And, you know, Justice Ginsburg expressed her regret for having been as outspoken as she was. I don't think Justice Alito has ever expressed any regret for speaking to these conservative groups that he speaks to. You know, they live in the world. That's probably a good thing that they do, you know. Supreme Court justices are not as sheltered as some other members, elite members of our society. You know, they live in their own houses, they drive themselves to work. you know, they don't make a ton of money as these things go, and they have thoughts. And, you know, I would hate to think that, you know, they're sort of afraid to leave the house and spend time with like-minded people. But, you know, we obviously hope when it comes time to cast a vote in a case that they vote on the basis of the law as they understand it.
It's a question that you may not want to or cannot answer, but you know, some of us were very disappointed that Sandra OConnor resigned, because she seemed to have been the Kennedy before Kennedy became Kennedy. Do you have any comment or opinion on that?
I was sorry she resigned too.
I'm sorry, what?
I'm also sorry that she resigned. You know, she would have had another, she's not very well right now, but she would have had another good 5 or 6 or 7 years on the court. But she felt she had to resign to take care of her husband. That proved not to be possible, actually. So that was, you know, that was too bad. It was unfortunate. Hate to end on such a down note as that, but, you know. But thank you very much.
Thank you all. I told Linda before the program that this audience would have diverse and tough questions, and you have lived up to those expectations, so thank you. In honor of your speaking here and of the person who appointed Justice Stevens, we have a set of pens with the signature of Gerald R. Ford.
Oh, that's great.
And they are both in working condition, and if you are so inclined, she would be glad to sign your copy of her brand new book with these pens. So thank you so much for coming.
Oh, thanks for having me.
This is great. And I'll give that. And before you go, a commercial for what's coming up. We have flyers in the lobby for both programs, 4 more this fall here at the library and several at the museum, because as you know, we are a bi-coastal institution, and people think I have a psychological issue when I say that. But at any rate, we have some terrific programming coming up. We're having James Rosebush talking about his new book on Reagan coming up in October. Michael Cohen coming from Boston to talk about the politics of this election just before. Actually, he's going to be comparing this new election with 1968, which he's written about. Leah Wright-Regur is coming also in November, talking about the state of today's black Republicans. And then in December, a program on the Shah of Iran by Scott Cooper, who has done research here at the library and has spoken in the past. The museum will feature a reprise of David Priest, who spoke here about the presidential daily briefing, and if you missed that, it's a wonderful program, so he'll be speaking at the museum. And Van Hipp will be talking about terrorism and national defense and security issues in November. And we have an invitation out to Senator Gary Peters. We're opening a new exhibit on space, and we're hoping he can come, but as you can appreciate for members of Congress, the schedule is rather difficult, so pinning him down, the spirit is willing, but pinning down the date with his staff is a bit of a problem. We have new evaluation forms in the lobby, and there's a box to put them. We would love your input on what we're doing and how we're doing it, and your ideas for other things we might do, so please feel free to fill that out. As I said, we have a book signing in the library with Linda, and a chance for you to ask all the questions you were afraid to go to the microphone to ask. We'll keep her here half the night. And of course, a reception with great cookies as always. So thanks so much for coming. Happy September.